excited is the right word. The conversation is a bit dark, but we're still really excited to impart knowledge today. Our producer on the back end, how is it? How are things going?
Clear.
All right. All right. So I'm just going to wait for a few more people to join, and then we'll get right into it. But we're super excited. You guys are going to learn a lot today. Yeah. Okay, so let's just dive right into it. So my name is Shina Chinyana. I work with the communications department here at Barefoot Law, and I am joined by two very brilliant lawyers who also work here at Barefoot Law, obviously, who are going to introduce themselves.
Hello everyone, we are very excited to have you. Thank you for joining the live. My name is Alinda Shuban and I am a lawyer with Barefoot Law.
Hello everyone, thank you for being with us today. My name is Alan Moya, Leo Barefoot Law, and I'm glad to be here.
Right. So if you're new to Barefoot Law in general, just our platforms, Barefoot Law is a non-profit organization that uses technology and innovation to bring justice closer to people. So we teach you about the law using technology. We do this with different digital tools. We do it through calls. You can call us on our toll-free lines. We do it through our social media channels where we put out information, legal information. We do it through social media, like you can text in a legal problem. We go out into the community. So we have several tools that we use to do this. Obviously, to get far, you have to partner with people with the same cause. So we're doing this under a project called the FED project. That's from Access to Equality for Women. It's a project for women that aims to bring access to justice to all women in all corners, from all walks of this world.
Okay, on Instagram they can't hear, so let's just
Okay.
let's make sure the mics are on.
They are on.
But the course that didn't think was very much is to speak matters first.
In the comments. Okay, so let's try.
Okay, sorry, I just found out that there was a technical issue. Can you hear me now?
Still can't hear.
Okay, can you hear me now?
They're still behind.
That's the thing there. The sound is still a bit off. Okay, so yes, so under this project, there are four organizations in the consortium. We're led by ASF. That's Avocats Sans Frontières. That's French, baby. Then Penal Reform International, Uganda Women's Network, and of course Barefoot Law. So, as part of this project, Barefoot Law, we've done research and the people that we've served, we noticed that many women out there don't believe that they should own wills, that it's more of a male thing, or that they have permission to own wills. And so we're like, okay, how can we help? So we're running a campaign this month called Wills for Women, where we are teaching women why you need a will, how to write a will. Do you need a will? What do you put in your will? And basically all things about wills. So that's what we're doing here, and that is what our lawyers in the room are going to talk to us about. Okay. So before we even get far into why you need a will or if you need it, blah blah blah. What is a will, Shimon?
Thank you, Shina. Okay, a will is basically a document. And I think just to add to what she mentioned, what Barefoot Law does is really get this huge idea called the law and simplify it for people. So you're not going to hear a lot of technical, hard things. We're going to try as much as we can to make sure that we explain what we're explaining. in a casual, normal way, because the law is for the people anyway. So a will is really just a document that you write as a person who is bequeathing or giving your property away to different people. It could be your partner, that means your spouse, it could be your children, it could be a relative, it could be an organization. So it's a document that you put in your last wishes right before you pass on.
Wow.
Yeah.
Okay, so what makes a will? Is a will just a paper where you write, I'm leaving my car to my uncle, I'm leaving my phone to my sister? What are the things that make up a will?
Okay, so first of all, it's important for you to know that you need to be 18 and above, at least according to the Ugandan law, for you to make a will. So if you're 18, you're qualified to make a will. Then it needs to be attested. What that means is that you're going to get witnesses, maybe 2 people, to sign off and say, yes, we have witnessed that Sheena has written a will. They're going to have to sign on each page of that will. If it's 1 page, they sign. If it's 2 pages, they sign. That's also another thing that makes a will valid. But also, it's that you are you, the person who is giving your property, you're giving, it's in the statement, your property. It can't be a will if I'm giving away Alan's property. I write my document properly, I put my name, my people, my family, and whatnot, then I say, I'm giving away Alan's land located on, it makes no sense.
Yeah.
So that also includes things like, if let's say you are an executor or an administrator, that means someone who passed on gave you authority to look after their things as they are being distributed. That property is not yours, so you can't put it in your will. So if you put it in your will, that specific part will not be counted as part of the will. Yeah, so those are the key markers really of a will. But the other thing that makes a will is that by the time you made it, you were in your right state of mind. What the law calls it is that you had capacity. We're going to delve deeper into that conversation, I think, later.
Okay, so is there like one template rules? Are all wills the same? Is every single will the same?
Okay, so there are 2 types of wills: privileged wills and non-privileged wills or unprivileged wills. I don't know why they decided to call some privileged and others not privileged, because it sounds a bit interesting. But yes, there are privileged wills and non-privileged wills. So the privileged ones, interestingly, it's a category of wills that is only for people who are in the army or people who are at sea, let's say fighting a war or something like that. Mariners at sea, that's what our law says. So if you are in the army at war or you are a mariner at sea, then when you write a will, that will is privileged. We're going to get into what differentiates a privileged will from one that's not. So any other person like me, you, for us, we're not in the army. We are not in the army, and we are not at sea fighting some war. For us, the wills we write are not privileged. So there's also a format for those ones. So those are the 2 types of wills.
Okay, that makes sense. Let me jump to Alan. But before that, if you have any questions so far, please feel free to put them in the comments, and Alan and Shivan will answer you. So Alan, me, surely I'm young. I'd like to think I'm young. I don't have assets. Do I also need to write a will? What am I leaving behind? Who exactly needs a will?
Thank you very much, Sheila. I think that's the biggest challenge with people when it comes to making wills. They think that it's about what you're leaving to people when you die. Now, as long as you're above 18, at that point, in terms of the law, you can say what you want and people will believe you, because people who are below 18 don't quite know, by law, don't quite know what they really want. So today you say, I want a car. Tomorrow, no, I don't want a car. I want a cake, I want ice cream. So you really don't know what you want, even if you think you do. Now, at 18, there are certain things we believe, because you're now an adult, that you're sure about. Now, that's what makes a will unique. It's not the last distribution of your property. It's your last testament. When we use that word testament at law, we mean the last wishes that you have, that you're putting forward for us. Now, it could be that, I'm going to give a very sad example. It could be like maybe you had problems growing up with your parents, and you begin to think, do I want my final resting place to be next to that parent who didn't treat me well, or in that village where the people never really liked me? Now, you may not have property, but you need to be the one to decide on where you want to be buried. Why should my body and my ghost rest in that place where they don't like me? So you go and make up your mind and say, I want to be buried there. So a will, in essence, is not just about your property. Yes, it's about property, but it's also about the wishes, the things you want the world to know about you that you want to leave behind, where you'll be buried. Let's say, even people who are 18 have children, even if they don't have property. How do you want your children taken care of? Because if you do nothing about this, what's going to happen is they will say, but that auntie has money. Who the auntie doesn't like your child? And then you're going to find that your woman has, pardon the language, has taken your child. And every day they're like, I even didn't like your mother. I didn't even like your father. Those things. So we write wills to take care of the people we care about, to talk about the things that matter to us. What if I was going to have something very important, like, for me, I was told that I'm going to be the head of this and this and this. So now I need to let somebody else take over when I'm not there. Otherwise, they'll give it to somebody else who might spoil things. So you name who you want to be responsible for that thing. By the way, we call that an heir or an heiress if it's a female. But we'll get into that a bit more later.
Okay. The best thing about spending your day with lawyers is you're continuously learning, because we're all learning, including me. So, okay. So, what your point is, it's not about leaving things behind. It's just about letting people know, after I'm gone, this is what I would like. Okay, that's interesting. So, what exactly, can you take me through like a breakdown of what exactly is in a will?
That's quite a long list.
Not bit by bit, but like the pointers, the things that must be there for it to be considered a will.
Okay. I'm going to just give a rough breakdown, and Shivan is going to help me where she finds that I've left out the things I don't have and I didn't plan to put in my will. Okay, so from the very onset, she mentioned the first thing. For a will to be a will, you need to have a person making that will. Now, so the first thing is, we want to know that this is the will of this person. So you put, your name must be there. Your name identifies this will as your own, first of all. Then, obviously, like, there are names that are common. Like, you could find that there are 10 Alans, even who are online listening to me right now. So how do you know that the will belongs to this Alan and not that Alan? So you like put your full names. You must have your address there so that they know, oh, it's the Alan who comes from the other place, not the Alan who's in Dubai or something like that. Of course, your age, because we need to know that this isn't a 16-year-old pretending to make a will that he's not supposed to. So your age must be there. Then you need to make certain things clear. Like Shivan said, I am of sound mind, which means I have the capacity, the legal capacity to make that will. So you need to make it clear that I am of sound mind. And if at some point you made a will before, then you have to also make it clear, like, yeah, I may have done wills in the past, but this is my real last will, the final one. This is the one. So now people definitely know that this is your will, this is what you're doing. So apart from that, then of course, depending, we all have families. You can't say, me, I don't have family. Hey, were you hatched? No. So, so you may not have kids. You may not have a spouse, what we call a husband or wife, but you definitely came from somewhere. So you have a family. And this is Uganda. We are a very cultural society. So our family is not mommy, daddy, child.
Siblings,
sometimes it could even extend a little further than that. So you're going to need to state who your family members are. If you're married, this is my wife, or this is my husband. I'm definitely unmarried, but I have this child, that child, the other child. So you have kids. Now, like I've said, we are in a very extended society, so you could have a judger or a parent that you're also looking after, like without you there,
Yeah.
it's assured they'll drop dead.
Yeah.
That's what we call a dependent apple, somebody who relies on you entirely for their well-being.
Okay.
Without them, they're kaput. So you put that person there in the will. Now,
Is it a must to put them there?
yes, because they have already, like, I mean, you took the responsibility upon yourself. Do you want them to die when you're not there?
Okay.
No. So they must be included as members of your family, obviously. Then we're going to talk about the properties you have. But property doesn't really mean I have 10 pieces of land here. It means like everything, like imagine, like you know how kids are? You just look at a child and you touch something like, mine,
Yes.
mine, like everything is theirs.
Yes.
So like anything, you would also have that instinct towards like, oh, that's mine.
Yeah.
Like you hear a song, you say, I'm the one who made that beat.
Yes.
That's your property. I wrote that poem. I wrote that song. So these things may be things you do not touch,
Yes.
but they're property. Of course, then we talk about the property that actually exist, like my car, my phone,
And
those
lots of
things.
land.
And then you also talk about the things that you are sure will be yours. Don't say, I might win a bet, so let me put that in my will. But things you're sure about, like I've worked for 25 years. At the end of my 2060th year, I will be entitled to pension. It's guaranteed. I don't have NSSF in my hands right now, what I've saved, but I will get it in a couple of years' time.
Yes.
You don't have it now, but it's guaranteed.
Yeah.
You can put that in your will for someone say, when I pass away, my NSSF, which will be given to me if I were to reach that age, I live to Shivan. Guaranteed. So Shivan just says, it's okay, it's okay. I may not have gotten the land, but
It's
there's
coming.
money
Yeah.
coming, that kind of thing. So you're guaranteed those things.
Okay.
What else? What else would I think is more vital than that? Obviously, you've told us your properties, you've distributed your property, and then the things that are more pertinent after that is a will doesn't enforce itself. I think at law, if I would look for a word for enforcement, what word would I use? Like it doesn't put itself into action.
Yes.
So you need somebody to actually do the heavy lifting. Like I've written a will, I've left everything to Shivan, but now imagine that Shivan were 15 years old, 16 years old. She can't like get up and go with a piece of paper and say, oh yeah, my dad left me this and this and this and this and this.
Yes.
I want it. My people. So we need somebody who's responsible for gathering all these things and making sure that they get to Shivan. This person is also supposed to make sure that this time we're not talking about Shivan.
Yes.
We're talking about the other person who doesn't want to be buried in a certain place. Now, somebody has to make sure that they do not get forcefully buried where they didn't. So this person must make sure all your wishes are fulfilled. That person is called an executor, so you need to name someone.
Okay.
So if you had kids, you also need to make sure someone's going to look after those kids. But I think I'm talking too much.
No, you're making a lot of sense. It's okay if you're making sense.
So just in case of anything, I'd like Shivan to like jump in with something that I may have left out. So you've told us who's going to make sure that your will comes through, like everything, your last wishes is like your genie that makes sure that everything you say, my first wish, I want to be buried on the moon. Done. I want all my cars to go to this one. Done. So that's an executor for you.
Yeah.
Then, separate from an executor, it could be the same person, it could be somebody else. You need someone who's going to take care of your kids who are below 18. Why is this? The law tells us that parents have a responsibility to look after their children. So now, when you're not there, then what happens to those kids? Talk to somebody and say, Sheena, I think you're really good with kids, and I know you like my kids. So when I'm not here, will you like look after my child, make sure they go to the right school? If they get bad marks, you take them to the naughty corner, things like that.
Yes.
So once all that is arranged and Sheena says, it's no problem.
Yeah.
Put Sheena's name down, put her address down. Sheena will look after my kids, they're sorted. After that, what else do we need to look out for? I need to sign. Signing will tell people, I think you had Shivan talking about that. Signing will tell people that, the Alan that's named up there has confirmed that this is definitely his. So Alan will sign that will, and I can read, I can write. But if I couldn't do any of those things, well, I have a thumb. I still have a thumb, 2 thumbs actually. So you just dip it somewhere, stick it right there. That's definitely Alan's will.
Okay.
And of course, sorry, the witnesses, like you must have, she called it attestation. Now, that means that you must have people who, in case of anything, will say, I was there. I actually saw Shivan. She even tapped it twice, then she stuck it on the paper. Yeah.
Okay. Actually, now Shivan, Alan said something about. Alan said something about kids. Now you know in this Africa of ours, you can have a home where there are like 19 kids, but only 3 are yours. Are you supposed to put all those 19 kids in your will?
Interesting question. So, no, that's the short answer.
Okay.
You're not supposed to put all of them in your will.
Mm.
If you want to, you can, because again, we mentioned that a will is your last wishes.
Yeah.
What you want is what you do.
Mm.
However, the children that depend on you wholly, which I think he explained, of if tomorrow you woke up and died, tomorrow you are no more, these children have no way they are going to survive. Those are people we call dependent relatives.
Okay.
Now, a dependent relative, it's in the word, is a relative. They have to be related to you, blood.
Okay.
So it's not just a friend of a friend's sister who you look after. That's not a dependent relative because they're not your relative. The law clearly stipulates who a relative is, the Succession Act. When we speak about the law today, for your reference, we're going to be talking about the Succession Act of Uganda and its 2022 amendment. So the law defines who a dependent relative is and clearly states that the person has to be your relative. But it's not, and as you mentioned, especially in African society, the term relative is loosely used. So a lot of the time people also include people who are not biologically related to them in their wills, and that's okay.
Yes.
Because you'll find, let's say, families are saying, no, why did they put that one in the will? That one is not related to us. But this is what the person who has whose will it is wanted. That's what they wanted. So if a person is put in the will and they are not blood related, and that's okay. If the person is left out of the will and they are not blood related, it's sad, but
it's what it
is what it is.
Okay. Yeah. So, in my scenario that I gave you of the 19 kids, let's imagine the man was, or the woman, sorry, was taking care of all these 19 kids. Like, yeah, this cousin came, now bring that one. This one came, yes, they're all related, but she didn't legally adopt them. Are those her kids? Are those, because they're her dependents, yes, but are they supposed to be in the will?
No, again, we say dependent relative.
Yes, they are the woman's relatives.
If they're your
but
relatives,
they're not legally adopted. Is that okay?
Yes. If the person is your dependent relative, meaning they depend on you for their sustenance, the one who called all that 20 people into your home, you started a school in your home and started educating the community, and they're all your relatives. So somehow you'll need to make provision for them. But I think Alan will come in on here because I know that 2022 amendment mentions a certain age after which you are not removed, but I think they mentioned that when you hit 25, the law anticipates that at this point you are old enough to look after yourself really.
Yes.
So at that point, the whole conversation on I am a dependent relative, what may not suffice, but I think Alan will come in on that. Yeah.
Okay. I hope you guys are putting in the questions in the comment section. Alan and Shivan here brought knowledge in abundance. So just keep the questions coming. Producer, do we have any so far?
Yes, we do.
Okay.
Ben Okito is asking, Alan, is it proper for me to give my wife to write my will on my behalf in case I'm not able to?
Actually, this is something Shivan touched on. When she was telling us about those people who are privileged, who can make wills that have privilege and the non-privileged wills. Now, what really sets apart those two kinds of wills is this one thing, right? Your will must be in writing, it's yours, you wrote it, if you had the ability to write, signed it in the presence of witnesses who must be at least two. Now, that's a will for every, what in the army they call it wananchi. We are very civilian, like we do nothing. We just eat food, sleep, and enjoy peace. That's us. You can't go out of your way and just say, I've delegated the duty of my business of the will to somebody else. Now, that's an unprivileged will.
Okay.
A privileged will, like she mentioned, is for people in the armed forces, people in the Marines, and things like that. Now, those people, because, well, for you, if you cross the road well, you eat well, you take the right medication, the likelihood that you will just die is very slim. Now, when you're in the armed forces and you're at war, you could get up, everything seems kawa, and the stray bullet comes and finds you.
Yeah.
So because of these kinds of circumstances, they give them that leeway. So a privileged will is more relaxed in terms of what the law requires than the unprivileged one. What does that mean? It means that, for example, I'm going to make a will and I'm in the armed forces. The two of you are here. All I have to do is say, by the way, that house that I keep here is for my wife. The other car, I'm going to give it to this one. So you've heard what I've said. Even if I can put it in writing, you guys heard, I have a will. I have a will, which you cannot do when you're on age civilian. You also can do what Ben has just asked. You can simply say, let me tell you what I want in my will. I have 14 cows. Each of my children is going to get one cow. And then this person will also get the other suitcase of clothes. Then the other one will get my shoes, like you see. And then Sheena will sit down. Sheena will jot down like cows. Each son gets one. Each daughter gets one. Shoes will go to this boy. Suitcase of clothes will go to, like, she will write everything out. And even if I'm not there, let's say something should happen before she can give me that piece of paper, that's a will, because it's privileged. But now for you, when you're wananchi like us, you have no excuse for not doing all these things, right? So the law will say, you should have taken the time and done things the way they were supposed to be done. So unfortunately, I'm giving it as a general position first. Unfortunately, you can't just tell your wife, make a will for me, and then she keeps it. That's not a will, because one, you are the guy who made the will. So if you didn't make it yourself, they'll be like, that doesn't seem like a will at law. However, that's not to say that people who may have like visual impairments, people like me, well, who can't like really see everything as clearly as they should, or people who may not be able to hear, or who cannot do all these other things, can't make wills. You're 18, you have the right to make a will. So let's say you're like me and without specs you'll see nothing. You can say, Sheena, write for me. This is what I want. Then I'll narrate everything and then Sheena will write it down. Then I say, read it for me. And then Sheena will list everything, obviously, because I trust Sheena. She will not have written that extra one cow goes to Sheena. So if there is a witness like Shiva, we're safe. Shiva will say, that is exactly what's written, what you just had. So they say, okay, where do I sign? Then they'll get my thumb and stick it there. I have a will. I didn't write it, but someone did it on my behalf. That's legal. That's very legal. Even it's legal to let somebody write on the paper and you read through and then you sign or put your fingerprint. Yeah.
Okay. Thank you, Alan. Okay, so keep the questions coming, people. So, Shivan, back to you.
Yes.
Now, imagine I'm married, and towards my death, my husband annoys me, and I decide I'm not going to put this man in the will. Is there any legal implication? Of course, that's not what we're encouraging, but my question is it mandatory to put your spouse in your will?
Okay. So this is the beauty of having a will. It's yours. You do what you want. If you don't have a will, however, the law will stipulate how your property is going to be distributed. And according to the law, it will cater for your spouse, whether you want it or not. It will cater for your children, whether you want it or not, if they're below 18. It will cater for your dependent relatives. It has a percentage for the customary heir. So those percentages are there if you didn't have it. But if you have the will, and you and your partner towards the end of your journey you're not on talking terms, you're done, you can put it in the will that I had maybe this land that I could have given this person, but no. You put whatever. However, there are things that the law recognizes as things that you both worked for. So it doesn't matter if they annoyed you, if they did what, the law will protect that other person's interest in that property. For example, what the law calls your residential home or family property. Your matrimonial home, let's say this office is where me and Alan were married. If we stayed in this home as our home, where we raised our children, where people came to visit us when they are saying, let's go and visit this family.
Yes.
You can't say, me, this property, you annoyed me, I'm not going to give it to you. No.
Yeah.
Because this is
Even
property. Even if you're the one who bought it, it was
okay.
considered matrimonial property. Both of you did what the law calls contribution. It doesn't have to be monetary. Our law has come out clearly and said, me, Shivan, I could have bought the house with my money.
Yes.
But Alan used to mop the house, he used to look
Buy
after the
groceries.
children, buy groceries, he used to give me moral support.
Yes.
So he contributed
Yes.
in maintaining the house. So when we are leaving the property and I go out first, or he goes out first, the house has to remain for one of us. I can't say, you annoyed me, now I'm giving the house to my church.
Yes.
No. So you may be annoyed and choose not to give your partner your personal property, but property that you both have an interest in, which is family property, your house, things like that, you have no right. The law will say, we acknowledge that you're angry. But unfortunately, you entered this thing that you knew.
Yes.
So yeah.
Okay. So, Alan, you mentioned earlier about something about putting in your property the things that are coming. No, they have not yet come, but you know, for example, your pension, etc., etc. Then you also say something about a song. So, can let's say I composed a song. Let's talk about the possessions basically of the tangible possessions and the non-tangible possessions. Can you put all that in your will?
Yes, actually you can. Like we say, property is not just the things you can touch. Now there are people who, once in a while, a company will say, hey, we are looking for people to buy shares in our company. Or maybe does that. Lots of companies do that. So you go and you buy yourself shares. Now those shares grow in value. So now, let's say you had 100,000 shares, or even 100 shares for that matter, and they are worth something.
Yes.
That is also stuff you own. Same thing with something like a song. Now, music is a funny thing. In law, we call it copyright, I believe. It's a very funny thing. When you're alive, it belongs to you. When you die, the law remembers that that guy made a very nice song. So for the next 50 years after your death, that song is still yours. That means people can't just say, a full day. Then they go and start doing your song. They can't. Like, the law will protect you. So if you have kids and you have absolutely nothing else and you're like, my kids will not starve.
Yes.
Then you remember, but I have a hit.
Yes.
And that hit, every time it plays, I get portion and beans for my kids. So it's like, my child, you will not starve.
Yes.
My whole album, the first album is for the first child. Second album, second child. Like, whatever is played and the revenue that comes from that for the next 50 years after your death will go to those children. So the law will allow that for the music, for the art, if you're an artist, for your poetry, for even inventions. Like, if you're the guy who is going to invent that fly in your umbrella that I can use on a border, and I'm able to cash in on that, well, I can leave the benefit of that to my kids as well. Yeah.
Okay.
And I think even things like bank accounts, bank balances. Really, as Alan mentioned, even if it's a shoe, because you know sometimes people think, as you mentioned, I don't have enough. Even the earrings you're wearing, just say these earrings, I'll give them to our producer.
Shout out to our producer.
Shout out to our producer. She'll look good with really anything that you can think of that is yours, that you can touch. You don't also have to touch it. It could be what you said. It could be patentable, something you put a patent on, a copy of it on. You give it away.
Okay. Yeah. So Alan, you said something when you were explaining distribution. You said this album will go to my first kid. So let's imagine I have 4 kids, but that second kid has my whole heart. And so I want to divide 50% to that kid alone. Then the other 50, these 3, sort themselves out. And they're all under 18 years. Does the law allow me to say, I'm going to give one kid more and give these ones less?
Now, you see, when you have kids who are above 18, things are simple. They're adults. Like, an adult cannot start saying, for me, my father has left me hungry. That's an adult. Again, don't you know those things. But when you're dealing with children, the law is different. You will have to tell us why. I know, yes, he has your heart, or she has your heart. This is daddy's girl. But tell us why you think this one needs to eat more than everybody else. So for that reason, kids who are below 18, if they are, first of all, they will definitely be in school because they're below 18.
Yes.
First of all, there's a portion that must be set aside for them, like a 20%, even if you didn't have a will. They said, this will look after kids.
Yes.
Now, so you see, when you can't just say, let me give everything to one child and leave the others, or give them, but you have to give reasons. You said, for my favorite child, she has always had my heart. Oh, Shivan dearest.
Quite.
Yeah. You give her, but then make sure that everybody gets something that will allow them to continue living. Because I mean, if Shivan is living large and everybody else is barely getting, then they may also run to court and say, this one was just not fair at all. So you need to try and balance things out, especially when kids are below 18. Obviously, make special allowances for kids who have special needs. By special needs, I'm looking for a word. Like they may be differently abled. Yeah, they may not have the same physical talents as the other kids. They may be visually impaired. You might need to make special allowances for those. Same as what Shivan mentioned. Those kids who may still be above 18, but they're still in school. They haven't found a partner to get married to yet. You still need to make sure these people get something. So you can't just suddenly just quarter, sort yourselves. You can't do that. So you make sure it's a bit of a balance. Otherwise, they're going to contest your will.
Okay. That makes sense. So now what if there's that one child, the way we had the child who is the favorite, we have this child who is a problem child by all standards. And by the time of my passing, I was done and over with him or her. Can I leave that one out of my will?
It will depend. If this problem child is below 18,
no.
Shiva stated it very well. You have your anger, look after the child. If you're above 18, you say, of all my children, I love this one the most, this one has done this. That's the problem with you, Malcolm. Every money I give you finds its way to the bottom of a bottle. So to protect you, I am not going to give you anything because you've eaten enough. You've given a reason, basically. So even if he runs to court, the court will say, hey, this man made his wishes very clear. Your mother was very clear about what she wanted. One, she gave you tuition, you ate it. She gave you retake money, right, found its way into gambling and betting. We don't know. So now you want her to give you more. She has made it clear, I gave you enough. I think with your bad manners, you don't deserve to take any more of this. People need it more because really. So if there's a reason, you are others. The law will not force you to give people things you don't want to give anything. So it's okay to leave someone out, but to be sure, put a reason.
Okay, so Shivan.
Yes.
Okay, producer seems to have, it seems there's someone who has a question, so take it away.
Okay, so Mweba Zerinito is asking, how do I will everything to my 11-year-old daughter?
Okay. So according to the law, there's something that is called a trust. Basically, it's this place, let us call it a place, where a person who is a trustee is going to keep this property for a beneficiary. So in this instance, it will be, let's say, your sister who will keep your property on behalf of your child, who in this case is the beneficiary. That's usually the arrangement. So you create a trust, and then in your will state that I have given all my property to my dear daughter, Ariana. But because she's still 11 years old, my sister, Patience, is going to be looking after this property until Ariana turns 18. The reason why people usually create trust instead of just putting it in a will is because a trust is properly protected under the law. There is a law of equity and trust, and there is how a trust is supposed to function. So most times you find that the child is better protected because the law is on their side. Sometimes when you just put it in a will and leave it there just in the will, the family will come up, people will come and say different things. But when you put the property in the trust, then give it to the trustee to look after it, they know they are just that. They are just a trustee. You've entrusted them with your property, they are a caretaker until your child is of age. So yes, you can give all your property to your child, it's just that you'll have to place someone in the position to look after it as the child is growing. And then when they make 18, they have the right to take over the property.
Okay, may I add a little something there? Okay, so on top of that, the law has actually developed quite a lot, especially this law of succession. Before, they would give somebody and say, you are looking over after this property for my kid. Then that person would just be like, it's been long since I drove a new car. They sell a plot, and they say, but these kids need to go to school. They are the ones driving the nice car.
Yes.
So now the law has changed a wee bit in this new act, the amendment that came out, that you now need consent before you just go out of your way and sell the things that belong to what we call a beneficiary, the children, the wife, and all those people. So you now need to go ask for permission. If the child is below 18, like we have the 11-year-old child, you may not ask the child because the child will not know. So, are you sure you don't want that bouncy new car? Go buy. Are you see?
Yeah.
So that's why we mentioned that it's very important that you have a guardian, someone who's going to take on your parental responsibility, somebody you trust. So when you have that guardian in place, the guardian will either reject or give permission on behalf of that child. Say, you want to sell a plot in Muyenga? To buy a fielder?
No.
Doesn't make sense. So, of course, they're allowed to go to court to say, I tried to get permission to sell this property, and they say, no, but I want the court to say yes on their behalf. And the court will listen and be, really? Does that make sense? So the court will protect you as well. But it's a very, very good thing that you have said. A trust is actually the much more secure thing that you should go with if you want to protect all your property on behalf of your child.
And I think it's also important to add that especially for matters that involve children, the courts are very, very serious about protecting the best interest of the child. So I know there are times when a lot of people fear that my child is going to remain here alone, then no one is going to protect them, but the courts are fronting the best interest of your child. So that's why, for example, you could buy property in your child's name, but even you, the parent, before you transact in that property, you have to first go to court and say, dear court, I bought land for my child Sheena, and I want to pay her school fees. Will you allow me to sell it? And yet it was your money, by the way, that bought that land for that child. But the court wants to protect the interests of that child. So for parents out there who want to create such relationships or such protections for their children, they should know that the court will be able to protect their children.
Okay, thank you, Shivan and Alan. Thank you for your question as well. Please keep the questions coming. So, earlier Alan said something about, he said, your will is only enforceable if there is an executor. So let's talk about who an executor is. Can it just be a friend? Who can it be? And then, it seems they're giving so much power to one person because I won't be there to say, no, I didn't say that. So, can there be more than one executor?
Okay, so yes, first of all, there can be more than one executor, again, because humanity is interesting. So, but the law anticipates that you're going to get the two people that you trust the most,
Okay.
or even more really, as long as they are 18 and above, and they also have capacity to, in other words, they are of sound mind, they can make decisions. The law will look at that as your executor. So you're protected. It's not just one person who is going to deal within your property.
Yes.
It will be an adult of sound mind who will be able to transact in your property, or two or three.
And they must also agree.
They have to. They have to consent, because you can put Mishina in your will. I don't know you like that. And I'm thinking, why? Why are you putting all this risk? Because it's a heavy, heavy responsibility for you to be an executor. Really, what an executor does is, the moment this person passes on, the executor's role jumps in.
Yeah.
Immediately you pass on like this, the executor, the family will probably call for that family meeting where the will is going to be read. At that point, the will is going to be read and you will be named executor. From that point on, you have to make sure that everything that the person stated in their will is carried on in the exact manner that they asked.
Sorry to cut you short. So is the executor named within the will that, okay, I've died, Shivan will execute this will?
Yes, they are. You must make sure, especially because if you write a will and certain parts are not within the will, for example, there's no executor.
Yes.
That's not exactly a
A
will.
will.
So you have to go to court for court to name an executor. We call them a court-appointed executor,
Okay.
which is a whole other process.
Yes.
So it's very important because it's your last wishes. Find some people that you trust and put them in. So the executor's job is going to be, after you have passed on and have started they are in charge of distributing the property the way you have mentioned it. But it's not just that. They are also in charge of making sure that in case anything happens, they report to court. In case someone has, let's say, refused to do what is
Where you wanted.
that person is really now like you. Really, what you will do in that time to protect yourself, that's what this person is going to do. That's why they execute. That's really what it is. Yeah.
Okay. So an executor only deals with the will, not with the things inside the will. So an executor can't, like, say, I'm going to take care of this plot of land, I'm going to take care of this family.
If the executor, let's say you have land, you've given it to XYZ. There are children below 18, but you also named guardians for those children. It's not the executor's duty to now say, now I'm going to look after the land. It's the executor's duty to tell the guardians, you are named guardian of these children. This is the property that was left for the children. You're supposed to look after it like this, like this, like this, the way it was stated in the will. Really, you're just an enforcer. You don't put yourself in a position of, I can drive the car, I can do whatever I want to do because I was named executor. Your role stops at making sure the will is executed. It is carried on the way the person who has passed on wanted.
Okay, that makes a lot of sense. Thank you. So how? So now, then, who is an heir? Because we hear an heir, then we hear an executor. So how are those two different?
Okay. So the law of Uganda, at least the Succession Act, names what is called a customary heir. What that basically means is that this person is your successor. It could be an heir, it could be an heiress, so either a boy or a girl. An heiress or an heir is someone who will succeed you. What that means is that they will be the go-to for the family. Let's say if you are the head of the clan, they could be the next head of the clan. If you were the person that people used to run to in terms of problems in the family, you're the one that then, because they have, you're now going to succeed them, you're their successor.
Okay.
That doesn't make them an executor. It does not mean that if you are, it doesn't mean that if you're named heir, because you're also supposed to put your customary heir in your will. It doesn't mean that if you are heir, then you're the one who's going to be telling people. Now, the will has said that the land goes to this one, so you do it, because there's an executor to do that. You also do your part of being an heir. However, simply because you put someone in your will as an heir, doesn't mean that you can't put them as an executor.
Okay. All right. You said something. You said a customary heir has to be named. So I thought a customary heir has something to do with like culture and those things given. Like if this was the first son or the first daughter, then this person will do.
Okay, so beautifully enough, Uganda is a country that embraces culture. And so the law, the constitution, which is the supreme law of the land, embraces culture and protects culture. So even in your will, which is a legal document, the law will say, put what your culture considers your customary heir. So you put it. It's not something that's left for the confines of elders, clans, and tradition. It's also something that is legally recognized, and if you put it in your will, as this person is my customary heir, no one is going to challenge it because you put it in your will. Well, they can challenge it, but it's in your will.
Okay, so let me direct this one to Alan. So earlier you said that what makes a will valid is a signature. Let's talk about a signature. Let's first put the fingerprint aside. So these big people in the country, we can let's say the people that sign our money, we can see their signatures, right?
Yes.
So what's to stop person X from writing a will? They put that person's name, they draw the signature properly, and they say now this is it. So how do I know that someone has not forged my will and written it as me and even forged my signature?
You have to be a very brave woman before you forge this thing. Okay, like in any other situation or circumstance, if you forge like a document like, I need to get into the exam room, I forge an exam room certificate or something, and I get in. You're not getting lucky by the way, but you could get lucky and you get only 2 years.
Yes.
But this one is a really big thing. In some cases, you're going to get 10 years. You could even get life imprisonment because you went and Bank of Uganda governor thing. And you've done your thing. If they catch you, you're finished.
Yeah.
You won't get 2 years. In law, we have 2 types of offenses. We have the small ones called misdemeanors. Then we have those really, really big ones where you cry felonies. This is one of those second big ones. So you're going to really suffer if you're caught. And I'm now coming back to your point. First of all, it's a terrible thing to try and do because it's going to hurt you very much.
Yes.
But also, if we think the signature is forged, there is an officer in government whose job it is to look at signatures and say, based on how this signature looks, this Sheena here is left-handed. She writes like, and this signature was written by a person who comes from this side, so it can't possibly be Sheena. Also, this ink is too new for Sheena. No. So things like that, they can easily catch the person if you contest. But then, the double protection is this. Sign here, sign every page. And on top of that, I think Shiva has stressed this like 4 times already. Witnesses.
Yes.
Like, okay, you're saying that Sheena signed this document. Who was there? You start looking for uncles, aunties, but remember, if they also lie, they're also going for the other offense of 10 years of life imprisonment for forging that will. So people have to be there and be like, honestly, I wasn't there. They're saying I signed here. It wasn't me. I wasn't a witness. I think so. You must have a witness to back up that signature that is really there. So you make sure you sign at the spot at the back and on every page. And it's not just you. Even these witnesses will sign every page to show that Yeah, we were there.
There,
She
she
signed
wrote
on this.
that.
She wrote this one. She signed there. So I also signed here. Shivan also signed there. So like we are all aware of what really happened. So it's really something to be careful about. And if you're a Mufede out there, I would really advise it that this one you leave because it doesn't end well. Yeah.
Ah, okay, that makes sense. So, oh, okay, we have a question coming in. Producer.
So Abumatu comments, what's the deal with this sexist belief that men die sooner than women? Can't women also write wills? Why is it men to write? Why is it always men to write?
That is a very, very
Fantastic question.
fantastic question. And I think that's what Sheena started with.
Mm.
And I think that's really one of the biggest points of this project or
Mm,
this
the
campaign that we're
Yes.
doing for Wills for Women.
Mm.
It's important for women to know. We're starting from the point of the Constitution of Uganda gives you, as a woman, the right to own property.
Mm.
Property can also be owned through inheritance, meaning you have just the same right like every other human being out there to write down your things, give them to a woman, give them to a man, but as a woman, know that you have the right. Write your things, write your dresses, your land, your cars, and bequeath them. So it's a very beautiful thing that you bring up. First of all, I don't know any scientific evidence that has shown that men
Die sooner.
die sooner than women. So it's important, yes, that women also put the protection for themselves. But I think Shina, you had something
On this or oh yeah, no, okay, so thank you so much for your question. It was very fantastic, and that's literally the reason we're doing this, to let women out there know you need a will, just like men need wills. As long as you own property or you have wishes, not even about property only, you need a will. So back to Alan. We're still talking about signing. So okay, I've signed, we've brought people, we've finished my will. Where do I put it? Do I keep it under my mattress? Do I keep it with the who do I give it to? Where can I keep my will?
The key word here is trust. Who do you trust? Now, I'm going to go very far back. Like those days, if somebody who was born 78 years ago passed away, they would have a best friend. They would have a sister. But also they had people at the local level like LCs they trusted, so you could say, I'm giving it to my sister, I'm giving it to my best friend, I'm also going to give to an LC official to keep that will for me. Things have changed a bit of late. Like honestly, you just, let's say you're now renting in Nigeria, like you honestly don't know who the LC is. So you probably won't know who to give the will to if they say, give it to the LC. But then again, it's another Boda guy who even snatched my phone last week. So you can't trust that guy. But the people you trust,
Not to say that that's the LC that was a hypothetical disclaimer.
So I'm not saying that it's only an LC you should trust, but it's always that there's somebody you trust. Like if you have no one you trust in the world, it would be a terribly sad thing.
Yes.
So you do not have an LC to give it to because, well, you're just renting here, tomorrow you'll go rent somewhere else. But, well, you have lawyers. You could go to a lawyer and you say, lawyer, this is my will, keep it for me. When you hear that I am dead, show up, tell them what I did. That's another place you could go. Or you have a bank account. But the banks do not only keep money and coins. They also keep things like wills. Let's say you bought shares, they can keep your share certificate. So any document that you have that you don't trust anywhere else, you can take to a bank. The bank will keep it. When your family says this one died, well, they'll come and show their family members, then the bank will pull out that will. Quarter. This is what your deceased person wanted you people to know. So the bank can keep it for you. If it's not a lawyer, your lawyer, by the way, is best. If it isn't your LC, if it isn't somebody you trust like a religious leader who is not going to go sell your land and build a church abroad, if you really trust this religious leader, go ahead, keep it with them. If you have a trusted family member, I said you have a sister, you have a best friend, you have a cousin that you know this person can't do me wrong. Give them and they keep for you. And I'm not saying that you give to one person, by the way. You could have a lawyer, but you also have a trusted sister or a trusted other family member. So those are 3 copies of wills you've given out. You also think, what happens if these people are careless? Or if they all died before me? Let me take a copy to the bank. Or what happens if this? So you always make sure that you have backup plans, plan A, plan B, plan C. So if it's not here, it's there. So and that way, it's very, taking you back to the earlier question, it becomes very easy to prove that you're a celeb and somebody forged your signature. Because like 2 people are bringing a will for Sheena. She signed. 3rd person brings a will signed by Sheena. We look at this will and I say, for me, my car, I am giving it to Alan. And like, yeah, but you guys were not deep like that. The other 2 people are saying the car's been left to this one, this house to this. So these 2 wheels are matching up. So we have to look at the old man out. You see? So that's why you don't keep it in one place. Make sure you have at least people who will verify, like I bring a wheel, that one brings a wheel. It's the same way. Everything is good.
Okay, so now I've written my will. Then I buy my plot of land. Now I have new property. But I've already written the will, so what do I do? Where does that plot fit into these people I'm going to leave behind?
Okay. I think that's where we started. Like, this is your final will and testament. That's what we called it. Now, obviously, you bought one border today, you change your will. Tomorrow you bought a car, you change your will. You bought a plot. Like, sometimes it's not always that you're going to get tired of tearing wills and writing new ones. And eventually you'll be like, but I'm entirely calling Walumbe Zayades to come for me. So to avoid these things, the law will allow you to do certain things. There's something we call a codicil. Now, a codicil in law is an addition or a change that you make to your will. So you can make that and you say, on top of the property I previously had, I now have this. I give this new property to my son or my daughter or to this person or the other person. Another thing, and I thank the viewer the listener who asked the question about why women can't write wills, because it's very, very important. Usually, like, we're very enlightened now, this generation, we know things, we write wills, we do this and we do that. You've written a will before, and now you're getting married. Will that same will apply? Because now everything you own, you left to your sister, now you're married. What happens to that property? Your status has changed. Because your status has changed a certain way, most of the things in this will not apply the way they used to. So somehow that will might have to just die off like that. You see, now those are 2 circumstances. The simple changes, do what we call the codicil, make an addition. But now there are big changes. You had 1 child, God has now blessed you with triplets. So what are you going to do about your will? You see? Now that's a very big change. You were single, searching, you found. Now you're officially married. So you're going to leave everything to this person, that person, that person. You say, and my husband, I've just remembered, my husband has loved me very much. We are now freshly married. Unless things change, I'm giving him that property. So you see, the big changes, such as marriage, such as new kids, such as the loss of certain kids, might necessitate that you wholesomely destroy the old will, create a new one, and in that new one you'll still say the same thing. My final, last time wishes. And I'm setting aside, I'm destroying all the other wills I wrote before, they don't matter. Only this new one matters. If it's the codicil we measure, you simply say, I am not setting aside or destroying my old will, I'm just making an addition. And then you go ahead.
That final thing reminds me of school. When we would be saving our coursework and you write final documents. Okay, thank you so much, Alan. So, surely I hope this won't be any of your viewers with everything the lawyers have said, but in the unlikely event that I pass away and I don't have a will, what happens to my property?
Okay. As we have mentioned, at least from this session, just get your piece of pen and paper and start now and make that will. But in the event that it happens and you pass on without having written a will, so in succession there are two kinds of things. The law calls it tested and intested succession. Tested means you wrote your last will and testament. That's where tested comes from. Intested means you didn't have a will, you didn't write,
You didn't have wishes.
you didn't have. Okay, maybe you had the wishes,
But you didn't put them on paper.
Yes, you didn't put them on paper.
Okay.
So in that event, the law provides for you. Under the Succession Act of Uganda, there are percentages stipulated, or there is a format on how your property will be distributed in the event that you die without a will.
Yes.
They mention the people that they will look after under the law. As I mentioned earlier, the law will provide for your spouse. That means you're legally married to, or
Not someone you're doing come and stay with.
not someone you're staying with and you have children with, but your spouse. That means your husband, your wife-in-law, your children, or the law calls them linear descendants. So it could be your children, it could be your grandchildren. The law says that it's up to the 6th degree. That means it's children, grandchildren, great-grandchildren, until the 6th time.
Okay.
Those are also provided for in your will if they are still there.
Okay.
Then you also have dependent relatives. We mentioned that these are people that are related to you, but they have been wholly dependent on you for their sustenance. So the law also provides a percentage for them. Also, the customary heir. The law provides for 1% of your property to that person. So in the event that you die without a will, you'll just go to, the law calls it the Administrator General. The offices of the Administrator General are usually where the Chief Administrative Officer, COW, where the COW's office is. So you can go there and as a family, you could elect someone, or you could even just carry your family. You go to the office and tell them, we had this person, they had all these properties, but they didn't have a will. So what do we do? They'll take you through the process of distributing that property to the different people under the law. Yes, but your property won't just go without anyone looking after it. The law has specific provisions and a way in which the property is going to be distributed. But there's also that chance that you will pass on and you have no one in life. You've also seen the circumstances
No
where
family,
you have
no dependent.
no family, no dependent, but you are a billionaire, for example. That if the government or if the state can't find anyone that will take on that property, that estate just, okay, let me not use a technical term. The estate will go under the Administrator General. So the state will be the one that is looking after it, let's say.
Viewer, don't be that person. Barefoot Law has templates on our website to help you. We have broken it down on how to write a will in different languages. Please go and check it out and make sure today you write a will. Producer has a question. Producer?
Okay, so Blessed Winnie on Instagram asks, can the person who witnesses be one of my beneficiaries in my will?
Okay. I think it's good for one of the people, for you to have people you trust. But you see, the danger is, what happens if I find out that I am taking your house in Chinda Minister's village? Won't I kill you tomorrow? So the law Mnagi is also very smart. So sometimes it wants to protect you, to be like, if you're going to sign as a witness, you get nothing. That way, your only job is to prove that the will was the real will and you didn't lie. Because these things happen, like, if I'm getting what? 1%. I'll buy rat poison. You're finished. So you see, to avoid these kinds of problems, they'll make sure that you have one job.
Yes.
Be a witness or benefit and eat.
Yeah.
That's it.
Okay. Okay, next question.
Okay, so Irene on Facebook asks, we have we have heard of situations where you will hear in a certain uncle or auntie claiming that the deceased told them how their property should be shared when they die, but it is not written. Are such statements valid?
No, they are not valid. We mentioned that there are two kinds of wills, privileged and non-privileged. For a will to be again, we mentioned that for privileged wills, they only apply to members of the armed forces and people who are at war, people who are mariners. So unless the uncle was an army person who was going to war, and then they mentioned to the other person that, oh, this is how you should distribute property, then that will be considered, because for privileged wills, it could be either oral, or it could be written, or it could be half oral, half written. There's a lot of leeway when you look at the act for privileged wills. But if it's, as Alan called them, wananchi, you're not a person in the army, you're a normal person like us, just coming and telling you that my phone, give it to my firstborn, that will not cut it. Yes, it has to be written down. If the person passes on and they didn't write anything down, it will be assumed that it was intestate succession and the person died without a will.
Actually, before we jump into the next question, this one is from me. Privileged wills, how do you prove them? Because I can just go and say, so when we were at sister, this man said, I'm the one taking the land, I'm the one taking the car, I'm the one taking everything. How do you prove that this is what the person said?
Okay, so even for privileged wills, again, when you look at the act, they're trying to create some kind of parameters, but they know that that situation is it's a very difficult situation. They are shooting bullets over you, so they are assuming
you don't have time
in
to
fear
write.
you're just going to turn to your next neighbor and tell them this and that. But usually the law prefers that they are going to be witnesses. Even as you are speaking, there should be someone who heard. You can't be the only person in the entire army that you are fighting
Who had? Yes.
It's a bit suspicious. Especially, for example, if the person had family. Because, again, we mentioned that a will, now this is either privileged or not privileged, is the last wishes of a person, and that person is of sound mind, or they have that capacity. According to the law, when they look at a will and, for example, they see there are no children, there's no wife, they start saying, did this person have capacity? How come? Can a person in their right mind pass on and not leave anything for their wife? So when the law starts looking, and now you come and you present yourself, you're like, yeah, me, I was the army commander, he told me everything is mine.
Yes.
The law will start saying, then they'll start investigating. So it's not blanket that, yeah, they told me because it's a privileged bill. No, there are still going to be some checks and balances to make sure that even what you're saying can be qualified.
Okay. Producer, any more questions?
No, none.
Okay. All right. I think we have come to an end.
Well,
Let's just see.
Is it the same in Islam? Because I know that I've had situations where in Islam, when someone dies, there is a way in which the mosque or the imam hands over things. So is that any different from the formal law system?
I think the law, first of all, the constitution, will give us the right to practice our religions. And that means everything under those religious beliefs, as long as they're in line with the law. So if there is a system that does not go against the law, and you're, let's say, married under that system, and this is how you would prefer that your things are distributed, as long as it doesn't go against the law, will not disadvantage the members of that family, it may pass. I can't be quite certain, because personally I do not ascribe to that belief, so I cannot quite say that I've read the Islamic law very well to know precisely how these are distributed. But just like with everything else, even customarily, we know that they will say they will prefer that goes to this first born, this goes to this child, and things like that. But if they are not in accordance with the law, then that will not pass, because the law is very specific about how it wants wills handled. So anything that deviates too much from that and disadvantages members of that family, it tends not to pass.
And then Winnie asks again, my auntie was rich before she got married. Now she has been married for over 10 years. Is that property part of matrimonial property?
Really, it's coming in for its nonsense.
Okay, I'm going to deliver bad news to. I know that those ones who like sugar mummies and bad news. So, first of all, when you are not married, any property that you accumulate is your own. When you get married, what changes is your status, but it doesn't change that you can still get things that can be your own. So even when you're married, there's property that you get that's your own. Let me give you an example. You get married this year, and then a property shows up, and you realize, I like that property, and you have all the money, you buy that property will be yours. However, there will be that property when you're married that you both contribute to. Let's say it's 10 million. I said, I have 8 million. Do you have 2 million? Yes, I do. You give me your 2 million, I add to my 8 million, we buy that property. That property is ours as husband and wife. Outside money terms, every day you go to work. I stay home dad, look after the kids. I make sure by the time you come home, the home is in tip-top shape. I have not contributed in money terms, but I have made this other contribution as a person that is unpaid for. And because of that, you went to work because there was a deal, you had to sign the papers and get 10 million. You got the 10 million and bought the property. I could argue that, go on. My contribution was making sure I am here so that you can go and pick up that money. And so there are properties where if it's a contribution-based thing, they are our properties. The law allows you, by the way, man and woman, either one of us can go out of our way and get property that's ours. By the way, being in your name does not mean the thing is yours. I could come and borrow money from you or take money from you and buy it and put it in my name. It doesn't automatically become mine because you contributed. So even when you're married, there will be property that's individually yours. That's why we say it's very fine, because there's that misconception that the guys obviously unproven die first. They must make wills. Like, the reason we're saying women make wills is because being married does not mean that now everything has gone to my husband. My husband has married me and all my property. No, that's not how it works. The wife can simply say, what I'm going to do is I'm going to give you this, or I'm going to leave you this. It doesn't automatically mean that, the day he married her, he married into money, or she married into money. No. You took me, but my property is mine, unless I say otherwise. So that's why in your will, even as a woman, you can give out what is yours specifically. Yeah.
And if you don't agree with the will, finally, we received a message in our inbox that's asking, if I don't agree with the will and I feel like my father cheated me, what do I do?
Okay, so it can happen. Again, you could be feeling cheated, you feel maybe that will is not adding up. According to the law, you're protected. As we say, the law here is really, the point is to protect you. You go to court and make an application for what is called revocation of that will. So under the law, there are grounds. You don't just come and say, they cheated me. No, it has to be either you suspect that there was fraud. That means you think that, well, this will was forged. It can't be. This will was forged. Or you suspect that you were unfairly treated, which means, for example, you're a child who is dependent on your parent, but your parent left you out of the will and there was no reason given. That's another suspicious activity. So you take it to court and you say, court, look at this will. Do you really think this will is fair? And court will revise the will and make its decision. So it's not, yes, we say that it's the last will and testament of the deceased person, and the person has the right to make their wishes, but it's not absolute or no one can say anything, no one can take it to court. That's what
things
that's
mind
what
has
I'm saying.
decided.
No. You can have your will and it's read to the family and family members are like, this will, no. So they take it to court and make an application to court and say, court, look at this will, interpret it for us truly and see if it was fair. And then the court will make its ruling and give a fair judgment.
Okay, but how do I contest with a dead person? Like, for example, if we are saying that there was some fraud in the mix, how am I going to prove that the person is no longer with us?
Okay, so the beauty about cases of succession cases, especially regarding the property of the deceased person, is that it is going to be you who is not fighting, but you who is contesting against the estate of the deceased. So even when they are, even in the title, the party, it will be Shina, Chinyana versus the estate of the deceased, so and so and so. So it's not you against a ghost, it's you against his estate. But usually the person who will stand in for the deceased person will be the executor.
And then what happens after the will is declared invalid?
So if you go to court and the court looks at this will and they're like, no, this will is not valid. Unfortunately, that estate now reverts and becomes an intestate estate. That means that now, instead of going under tested succession where you follow the will, you're going to have to follow the procedure under the law. So that means the law will take it like as if you died without a will. So you'll go and apply for letters of administration. That's another whole entire process. Maybe we'll get into it sometime. You apply for letters of administration. As a family, you will choose people, administrators, who are different from executors. Administrators are agreed to sit here as a family. We're like, Alan and Sheena, we think you're the best people to. So you go, you make the application, court gives you the letter, then you come and you're like, okay, we've been given these letters of administration, and this is how we're going to administer the estate. According to the law says 1% customary heir, we give you 1%. The law says this percentage dependent relative, they give you. The law says this percentage spouse, they give you like that. So that's what happens if they look at your will and they're like, it's not valid. You go and intestate succession.
Okay. Nabs Ambrose Mwesije has a statement for you, lawyer. Who told you something will happen to me? So should he wait until something happens, or he should do it now before something happens?
Okay, well, there's that expression in English about preparation. If you do not prepare, you're prepared to fail. Same way, like if you arm yourself in advance, things will not go wrong for you. Okay, they might go wrong, but they will not be as bad as the person who didn't arm themselves. If a dog is coming at you and you have only your hands, you could be finished. If on the other hand, you have a stick, you can hit the dog and you might survive. Now, these things are like that. I mentioned that in the armed forces, bullets are flying. There's a danger that you could be shot any day, so you might need to make a will immediately. And that's why they allow you that freedom to even make one verbally. Now, every day you get up, you go to work, you come back, and everything is fine. Tomorrow you do the same thing. But remember that for those of you who watch news, there's that station where they put news and it's just scary. It's like a horror movie. Every day there are people dying. You haven't told us that you're dying, but we are saying, why don't you prepare and be prepared than fail to prepare and things go wrong? Because, like Shivan has just told you, you do not want them to start splitting up your property. Remember, you wanted a certain child to be your heir, customarily. You wanted certain property to go to your spouse, your husband, in this case, or your wife. Or you wanted certain things laid out for certain children because you know this one has a huge career ahead of them. They don't need a lot. This one definitely might need a lot. Mulava, eh? So now you can prepare for that because you're the parent. You know your kids best. You know your spouse best. Or hope that when that division happens, what Shivan called intestate, that they will get what they want, and they won't. Because 20% will be taken off for the kids who are in school. Some Chiman may come and say, me, I am the heir. I want my 1%. Everyone will come and pretend, every day, he never told you people, but every day he would leave home, he would come, and he would give me a bunch of matoke. So without him, I am finished. But if you had a chance to write your will, you would tell us, I look after this person. Everybody else is a liar. They live and survive on their own. I don't know about them. So you see, you're putting your property and your family at risk by not doing the simple thing. They tell you, swallow this medication or you will fall sick. You say, let's wait for sickness. So that's the same mistake you'd be making. So it's very advisable for yourself and for the good of your family to prepare. You don't want your body to be chilling and rotting out here for 2-3 weeks because they don't know where they're supposed to bury you. Well, you could have told us. Yeah.
Okay, and then Navidia asks, who are dependents? My father usually collects children and brings them in our house, and now he has died. We want to chase them away. Are they dependents or they are not?
Okay. I think this, again, let us stress that the law only envisions what is called dependent relative. You must be a relative, at least according to what the Act says. It's sad that you could be someone that someone took on, a neighbor, a friend. However, if you're not a relative, you don't fall under the category of dependent relative. And really the reason that the law puts that cap is because they're trying to protect the estate of the deceased from the whole world. Because everyone could come and say, I know for me, he used to give me 100,000. I know for me, she used to give me this. So they're trying to protect and put a parameter because your estate can't be for everyone. So they put a parameter, they put a guard, and they're like, no, dependent relatives. So it's not just a dependent, you could be a dependent, but you're not related. Yeah.
Okay.
So,
And then Penny asks,
let me I have a follow-up question on that. Earlier you mentioned something about sixth generation. So does the law specify what type of relative I have to be? Is that the one of the sixth generation?
Okay, so there are two terms under the Act. There's lineal descendants, which people commonly call children, because in African tradition, again, there's no child, grandchild, like they're all children. So it's children to the 6th degree. That's lineal descendants. That's direct children. Dependent relatives on this side, I think the law puts them two categories. It's also not everyone, every relative, every grand aunt, there's also a specific cap. We're going to put those two terms down and you'll see the people that are qualified to be in that category. But there's also a limitation. Again, the law is not blanket. It's always very specific. Yes.
okay. Penny asks, can't we just make a will as a family in a family meeting?
Yes, it's a very good question because it actually comes up quite a lot. Like family just says, Can't we just decide? Me, I am not fighting with you. You are not fighting. You only want this one. Me, I want this one. I want that one. Can't we just sit down and just write the thing? Unfortunately, you can't. Like we said, it is the last will and testament. Like these are the last wishes of a person before that person can pass on. You can't make a will when you're dead. So it's like how people of a certain religion say you can only give your life when you're alive. Like when you cross over to the other side, you can't say, the gates of hell are very hot. They tell me what is within is terrible. Let me repent now. You can't. Like, cut-off point for the will is when that person is alive. After that, the next best thing is sitting as a family. When you go under the intestate succession that Shivan talks about, sit as a family, say, this is the person going to distribute the property. Agree. Can we all agree to this kind of distribution? Yes, we can. Okay, so take this according to what we've agreed, take that according to what we've agreed. But that is not a will. That is not a will categorically. It is just an arrangement you come to because there was no will and you have gone a different way to distribute that property.
Alan, I've got a question on Facebook from Brenda Mongin. Can you assist with getting letters of administration? If yes, what is the best way of contacting you? I think this is directed to Barefoot Law. And then she goes ahead and says, most people I have known who had written wills involved lawyers, but the reality is lawyers are very expensive for the ordinary person to use. How does one go about writing a will that is legal without incurring the lawyer expenses and at an affordable price? Thank you for this topic.
Okay, where do we begin? First of all, thank you for the questions. Now, because some of the questions need a lawyer to deal with personally, because you may have details that are sensitive, I'd suggest that you get in touch with us at Barefoot Law and a lawyer will help you deal with some of these concerns. Now, we are available on 039, if you have a pen and paper, please write, 039 217 7405. We are also available on 075 514 9984. We also have a toll-free number where you don't need to even pay a single shilling. You just get on. You don't need to rush. You don't need to rap about what issue you have. Take your time, explain to a lawyer, and we shall listen and we shall talk to you. It is 0800 22 0000. Apart from that, there are so many ways that you can reach out to us. On SMS, you just have to type the word law, leave a space, type your question, and send that to 6115. And we shall get it and we shall respond to you. Other than that, we have all these platforms like Facebook, Instagram, we're even on Twitter, what we call Space X these days. You can reach us on any of those platforms. We're very available and we shall help you. Now, a thing we may have not talked about is the fact that why you think lawyers are always involved in the will writing and all that. We are lawyers and we're not going to make it difficult for you. Sheena has told you that on our website we have wills available in very many different languages. We have Luganda, Lusoga, Nyashitara, English, and we are coming up with even more languages for you to be able to read. On that website, we explain exactly what the will is, what you need to fill in, why you need to fill in each part the way you should fill it in, and then we'll let you get on with the business. Simple as that. So you don't need to worry that now I've started, what if I'm calling death? You just have to fill that in. So just get to the website, fill in, print, you officially have a will. It's as simple as that. The one thing that we might not have made clear about wills is that executor person. That executor person is appointed in the will, but then we want to make sure they are doing their work according to the law. They need a supervisor. You people who are benefiting can't be the supervisors because the guy will be like, you're going to disturb me. I will not do this according to. But if you feel the person is messing up, you need to be able to report them somewhere so they can be dealt with according to the law. The law is there to protect you. So when you name a person as an executor, they go to court and apply to court and tell court, I have been named as the person who enforces this will. I need you to give me authority to go ahead. Then you go ahead. The difference between that executor going to court and a person who didn't have a will is here, the executor will still follow through on what the will says. They'll do everything, but they will be supervised by court. If they feel they're doing something wrong, you can run to court and say, that person is doing a bad job. That person is doing this and that. On the alternative, the other person that Shivan told you about, the administrator, is like an executor, but the difference is this person must follow through on what the law says, like the 1% for the customary heir. That's a very different person. That one has to apply to even get the right to even start doing that after a family has decided on who the person is. There, in the first instance, it is the person who has passed away who named you, and the court is only confirming. Yeah, I think that's pretty much it.
Okay, Ricardo made comments. I don't think I get the question well, but let me just say it out so that you can listen. He says, we have a customary heir and an heir, and an heir, I think, in the will, who owns the property of the deceased. In case he gave their share, to the heir of the will.
Maybe the person's share, the heir's share.
Yeah, so we have a customary heir and the heir in the will who owns the property of the deceased. In case he gave their share to the heir in the will. I don't think I understand the question.
I think, okay, so I think let's just talk about heirs generally. Maybe they'll find their answer in there. So before, and we're interested in having a conversation with Alan earlier about this, there was what was called a customary heir, and then there was what was called a legal heir. So right now, as the law stands, they provide for what is called a customary heir. And if you go to our website and download our templates, you will notice that there's a section for customary heir, who is basically, or heirs. So that's male. We have stressed that women can inherit property and also be heir. So a customary heir or heirs is basically, as I mentioned, someone that succeeds you, a successor. So there, I think in this person's question, the person might have had two different people. They had that maybe their clan has someone who they think is supposed to be the customary heir, and then in the will, this person has named another heir. So if that is the situation, Alan, what do you? I think we're trying now to decode the question, and I think that's the question. So what happens if the clan and culture has dictated another heir, but me in my will, I'll put my own customary heir?
Okay, so I think, thank you, Shivan, for that. I think what it's pointing to really is there's the customary one they have named, and for you, the one you have named may not be customary, but could be what Shivan has just called a legal heir. In the old law, before we got this amendment, the legal heir had to be the closest descendant. Like, imagine if you're firstborn, your firstborn would then be your heir, legal heir. Now, it didn't mean that they take everything away from everybody else. They're just your legal heir. They'll make sure they follow through on certain things and stuff like that, but they were not supposed to snatch property from anyone else. A legal heir could have been, like we've said that this month we're focusing on women, it could have been your firstborn daughter, could have been your firstborn this or that. Now the old law had a bit of an issue that has been rectified in the new law. It used to say that we could prefer, if there were two, like your two children, they would say, we'll go with the boy over the girl. But the new law says that that is totally discriminatory. If there is the two of us and Shivan is the firstborn and I'm the secondborn, if there is no one named, then Shivan would have to take that position by virtue of the fact that she is the firstborn, regardless of the fact that she's a woman and I am a man. Like that equality at law. Now, there is no law that allows a legal heir to start snatching property from any of the other people who benefit under a will or who benefit, such as the customary heir that we mentioned. So that would be wrong. And that person can run to court and be like, something is happening under here that I don't understand. Please fight for me, protect my rights. That's an option that's available to them. Yeah.
Okay. And then Anita Komgisha on Instagram is asking, can one write a will and leave it with an institution like a bank? I know we'd answered that earlier,
Yeah.
but I think let's just stress it for those that want to.
Yes, definitely. Yes, you can write a will and leave it with a bank. As Alan interestingly noted, banks are not just for keeping your money. You can keep documents that are important to you, including your will. So at the point when you pass on, you will have given instructions to the bank that when I pass on, this will that you're keeping, you'll give it to this person. Again, banks are trusted institutions. People trust them, so they know that when I tell the bank that they should give my will to Trudy, not give it to Alan.
Yeah.
So that's actually, I think, one of the biggest advantages of trusting institutions, because you know that your wishes will be followed through. So yes, that's the short answer. You can't put your will in a bank.
Okay, and then a very interesting question here. If I'm in a coma and they give out my property, and then I come back, I miraculously wake up and find they have distributed my property, can they give it back to me?
Okay. So let us stress that wills and the distribution of someone's property only apply after the person has died. Dying, medically, so not a death is when you have no heart rate, like you're dead, medical dead. Because even when you apply, let's say for letters of administration, or even when you apply for probate, okay, probate is what Alan said, what he explained of you've gone to court, you have a will, you are given permission, but you need court to get involved just to supervise. So that's probate. Even in those instances, you have to give the court a death certificate to prove that really this person has died. So that the court protects the person. The person could be in Mulagonga, they are still in a coma, but they are not dead. That doesn't mean you have the right to just start distributing their property. So succession and the law of succession only starts taking effect, or at least the will only starts taking effect after the person has officially died. There's a death certificate signed and sealed, you're gone. That's when your property can be distributed. In the event that you were in a coma and your property was distributed and you get up, that property was fraudulently given away, because no one is allowed to give your property to other people without your permission, unless you give them what we call power of attorney. If you have not passed that power on, people who are, let's say you're in a coma, so people who are ideally your next of kin or someone who is very close to you, has the right to make certain decisions. Let's say they need money to take you for a very expensive surgery and you have land. They'll ask maybe like your wife to sign off on that documentation and allow that to happen, because they have your best interests. But your family can't sit down because of coma and say, we suspect this person is not going to wake up, so you take the car, no, that's not allowed. And if it happens and you wake up, you can always sue them and recover your property if it's still there to be recovered.
All right. So Ricardo May came back as we wind down the last 15 minutes of our live. Ricardo May came back and to explain what he meant by his question about the heir. I mean, we have an heir who is written in a will, but he is a mulokole. So he didn't wear the back cloth, and the deceased was a customary believer by religion. But he divided his property. So the family decided to choose a person to take over the customary religion duties. Now, who is the rightful heir?
Okay. Thank you, Ricardo, for your question. And I think we started by mentioning that according to the law in Uganda, custom is appreciated and people are allowed to practice their custom and religion in the way that they want, as long as it does not infringe on other people's rights. However, if someone has said that me, the person I want to be my customary heir, is this one, it doesn't really matter if they are a Molokole or anything else. That was this person's last wish and testament. And so the conversation on how the family can now come and say, oh, because you're this, we are not going to allow, we want someone else. That could be a bit problematic. The person who was put in the will can actually go ahead to court and say, so I was never customary heir, but my family is saying I can't be customary heir because I'm a Molokole. So that's something the person can take on to court.
Okay. And then he comes back and says again, what is the time by law allowed to share the family property in case both parents are dead?
Thank you very much. Okay, so the amendment has brought a couple of changes that make sure that the property gets distributed. If you have a will and you've named someone as the executor, someone to enforce that will, by law, that person gets 1 year, strictly 1 year, in which to have carried out their duty. If at the end of that 1 year they have failed, anyone who's supposed to benefit from that estate, that property of a deceased, can go and say, he failed, she failed, we want this business taken care of. Then they will appoint someone called an administrator to take your place as the executor and do the work that you failed to do, that you're given originally. If the person didn't have a will and passed away, Shivan mentioned that you're supposed to go to court, apply for letters of administration after sitting down as a family and agreeing on that person who's who will have that authorization. We call letters of administration. Now, you get 2 years. If in 2 years you have not done everything you're supposed to do, you failed at your task, it should go to somebody else who will do what you were supposed to do by law. You are also supposed to run back to court, take an account. This is what I found, this is the property, it was like this, I've distributed it like this, like this. You render an account to court. That's why we say court exists to supervise these people. They just don't operate in a vacuum. So without doing things the right way, court is supposed to hold you accountable and say you failed, let's get someone else. You have 2 years. If you're an executor, you have 1 year. So if you're named, make sure people are not left hungry and suffering just because you like the bank balance or you like having your name on someone's title. Make sure everything goes where it's supposed to go in the period of a year. Yeah.
All right. Thank you so much, Alan. Thank you, Shivan. Producer, are there any more questions?
So far, I think we're good. I don't see any other questions. I think we can go to last remarks.
Okay.
Remarks.
This has been a very interesting conversation. I never thought talking about wills would be this interesting, but thank you so much. It seems the producer has a question of her own, so please.
I have 2 questions of my own. I remembered. One, I have a very bad handwriting. And so must wills be typed or they should be written in hand? But also, when they're written by hand and you don't understand, you can't understand the handwriting, what do you do?
Okay, so I'll answer the first question and maybe Alan could do the second. When the law says that will has to be in writing, it doesn't mean handwritten. It could be typed out and then you affix you put your signature, you either sign or put your thumbprint. So you can type it and put your thumbprint or sign it, or you can choose to use a pen and paper. But if you know that your handwriting is not legible, people can't read it, we would suggest that it would be best for everyone involved that you get it typed. But in the event that it is written and it can't be understood, or maybe even water pours on it, and the pad
The ink spreads out like
what
this.
happens, Alan?
Okay, quick advice, if your thing is handwritten, you see, when we own property, like you graduate from school, even when you pass P7, S4, you always laminate your things. If you're going to make it handwritten, to save yourself from water damage and all that, laminate your thing, because crisscrossing it will make that will invalid or inoperable at law. So also water, if there are parts that can't be read of that will, we don't know what was said exactly. We can say it was destroyed, it was damaged, and so you might need another will. Or the court will always find leeway, because the goal of the court is to make sure that you get justice. If the damage is at a point where there is supposed to be like a cassette niche at the bottom, but everything else matches up, you could get lucky. But anything that destroys the paper on which your will is will render that will invalid, unfortunately. So make sure you protect the will. Laminate it, because it's not like you're going to make changes on that same paper. Laminate it to keep it safe. Handwritings. I'm just going to add something small to what Shivana said. Surely, by the time you're writing and you have like a chicken handwriting, there must be somebody who can read your will. Make sure this person is a witness or is the executor in that will, so that they will look and squint and they'll be like, yeah, I think she was saying
10 acres.
10 acres. That's what she meant.
Yes.
So make sure it's something legible, because if it isn't legible, it's going to create issues for you, and people might either misinterpret, or the cost to the people you've left behind will be high, because they'll find a handwriting expert who can read any handwriting, and that person may struggle and eventually get something and say, me, I want 20 million, kumbe the estate is only 25 million, and you make a loss for your family members. So do the easiest possible thing that means that you're understood clearly and without ambiguity.
Okay, Penny says, can a handwriting expert in that case be used in court maybe?
Definitely.
Okay.
Yeah, definitely. They'll bring somebody who can read, because there's a guy or a lady out there whose job it is to understand the most difficult handwritings, even the ones for doctors. So they'll bring that person, and that person will see what you wrote and make sense of it.
Okay, sorry, the questions are trickling in now, which I like, as we, the last 8 minutes of our life. Ricardo May comes back again and asks, in the event that we have a stepmother living, but wasn't officially married, what's her share?
Okay, so as we mentioned earlier, and I think I mentioned that when the law is looking at the people that are supposed to be provided for under the category of spouse, they only consider those that are legally married. In Uganda, we have different forms of marriage that are legally recognized. There's a civil marriage, church marriage, Islamic marriage, there's a civil marriage, there's also Mohammedan, Hindu. So if there's also traditional marriage. So if the stepmother is not legally married, they cannot inherit property that would be the portion of a spouse. They can come under maybe friend, they can come under, I have a girlfriend, I have a, now people say wife, and they loosely use it. So the person in the will could say, my wife, but really the essence is that if this person was not legally married, they cannot get the share that's equivalent to the share of a spouse. You could put them in a will, let's say you've been living with someone for 20, 50 years, I don't know, and you're not legally married, but the person has been, you've been living together as husband and wife in quotes, then the person, you can include them in your will as your friend, or you can say to this person that I've lived with for all this time, I'm leaving them this, that, just that the law will not recognize them as your wife or husband, but you can still leave them in the will. If the person dies without a will, and you have a stepmother or father who was not married to your parent, that person is not entitled under spouse. Again, remember you said that if a person has no will, then the estate goes under intestate. And since the stepmother is also not a relative of the person who has died. Unfortunately, the estate will not cover for them.
Then he says, but what if my husband kuchalad?
Brings us to the question of kuchala. So, in Uganda, kuchala is not a recognized form of marriage. What kuchala is, for the viewers that may not understand, is basically your partner comes to visit your parents and introduce himself and say, I have interest in marrying your daughter. I'm going to come and marry her. That function does not amount to marriage. Even if you have come from that function and entered this man's house and stayed there for 3 years, you're not married. You're living together as friends who do other things, but you're not you're not married. So in order to protect yourself, and if you would want your partner to be able to take a share of your property as a spouse, you have to fall under one of the forms of marriage that we have previously mentioned.
Okay. And I think one last question from Ricardo as well. On Facebook, he says, we have a land that was given to us but the deceased ordered never to divide it, only to develop it as a family. In the will, it stated that in the event of failure to develop it, we hand it back to the clan. Now how can we manage such land in case the family fails to understand each other?
Okay. This was in 2 instances. When you make your last wishes known, they must be obeyed. That means you can say, I want this to happen this way and happen that way. But the law is very, very specific. There is something, I'm going to use a big word, but that's for a different time to break it down more. It's called a dead man's handle. Now, in law, when you die, you cannot keep property because dead people own nothing. Now, when you continue to direct people how to use a certain thing, like, I'm giving my property to this person. When they die, it must go to this person. When they die, it must go to the other person. Things like that that are without end, wishes that are without end, are called a dead man's handle. What it means simply is this. Your late father can say, the land must not be sold, it must be developed. And if they don't develop it, it will go. But they must also be very specific about the boundaries of their wishes. You cannot say, it must always remain with these children until time immemorial. That means you're holding them hostage on what they can do with what you have given them as their own. And the law will not allow such a thing. So you must make sure that it's definite. Like, for the duration of their lifetime, they can use that property and must develop it. But after that, they do what they want, their children and their children's children. Yeah.
Okay, we're just in our last seconds, and a very important question has come in. What if I have my receipt for the cement I bought for the house? Am I still not entitled?
So who has the receipt?
The woman.
The stepmother?
Yes, that's
Or the woman who has not
married.
been put in? Oh no. So if, again, let's go back into the conversation on matrimonial property and all those things. So the law protects people who are married. It gives them their things, their property, and it protects them that if they separate, or in terms of things like wills, that property can be shared between them. But if you contributed to property, this man or woman brought you into their lives, and then you said, you know what, let's develop ourselves. We're going to build a house, me I'm contributing this, me I'm contributing this. That property belongs to the two of you. It doesn't matter whether this person put in 200 million and then for you bought 50 bags of cement. There's a share in that property that can still be aggregated to you by the court. So don't feel discouraged that, oh, they're going to take my things. No, if you have your, especially if that's perfect, please keep receipts. It's very, very, very important to keep receipts. So if you have a receipt for the cement that you contributed to the home, perfect. In the event that there's a legal battle that happens in terms of the ownership or separation of that property, you present your receipt and you say, me, I have an investment in this property. I have a share in it, and my investment should be given back to me. Yeah.
Okay. All right, so we have no more questions and we're winding down our last few seconds. So Sheena, please tell the people whether they can keep asking us questions while they're watching these recordings, and when our next one will be.
Okay, so first of all, thank you so much for taking time of your day to attend the live and to learn from us. It's been an absolute pleasure moderating this conversation. Thank you so much, Shivan. Thank you so much, Alan, for always being available to do this, to teach. So you can ask us as many questions as you have. Barefoot Law is here to give answers. But before I get into the questions, just a reminder, you can download a will template and it's free. Like all Barefoot Law services, it's free. It's on our website in any language that you're comfortable with. For all your questions, you can reach out to us on our different social media platforms. You can reach out to us on text, type your question, lower your question, send it to 6115, or you can call in on the toll-free lines, the one that Alan read earlier, and we'll be more than glad to respond to you. So thank you, and have yourselves a blessed day. Bye.